session. Please be seated.
Good afternoon, everyone. We want to welcome you to the Tennessee Court of Appeals. Madam Clerk, are there any preliminary matters before we call the afternoon docket?
No, Your Honor.
In that case, will you please call the first case?
731 Real Estate Group, LLC, DBA Town and Country Realtors versus Joseph T. Fuzzell.
Thank you. We allow a total of 15 minutes per side. The appellant can divide their time between the initial presentation and rebuttal. However, we do not favor anything past at least half that time. So we don't favor anything past 7 minutes on the rebuttal, okay? For the appellant, you may present your case.
Thank you, Your Honor.
Yes, sir. What is your time you're going to reserve for rebuttal?
I'd say just 1 minute.
1 minute? Okay. 1 minute reserve? That's it.
Thank you, Your Honor.
Okay.
I'd like to begin by introducing myself. My name is Corey Hancock. I'm out of McNairy County. I practice law there. I was in Jackson with Mr. Mark Donahoe for about 5 years prior to that. I'm introducing myself because I was a non-traditional student. I was a blue-collar worker for the majority of my life and then decided to go back to law school. And that's why this case is important to me, because this case is going to address some issues about the informalities that General Sessions courts have. General Sessions courts have some informalities that allow the common person, I almost hate to say it, I believe it was Robert Keebler that says the General Sessions courts rub elbows with the ordinary people. I don't like to say ordinary people. I don't believe because I have a law degree or something to that effect that I'm above anybody and look down on anybody and call them peasants. But I do believe what we're facing here today is bigger than myself. It is bigger than my client, Joseph Fuzzell. It is bigger than the appellee's side, which is Town and Country. It's bigger than that because what we're addressing here today is something that the legislature has felt important enough to have statute after statute that says cases in General Sessions courts appealed to the circuit court or appealed to the circuit court should keep the same informalities that the General Sessions courts have. Now, I'm going to be arguing a little more than what we're used to. We're all used to. Are you telling us
that a case that's tried before General Sessions Court, when it's appealed to the circuit court, should proceed in the same manner in the session court as if it was in the shall proceed in the same manner in the circuit court as it did in the Sessions Court?
As far as to the informalities, and I'll get to that, and I didn't mean to go this deep into my argument regarding that, but I just want the court to know why I'm passionate about this, because I believe this is bigger than me and this is bigger than my client. This is about preserving the right for the common folks to be able to go present their case in General Sessions, and then if that case gets appealed to a circuit court, it not be kicked out because they didn't do something that only I learned in law school. So I'm going to proceed with that, Your Honor.
Go right ahead. Present your case.
Here, what we have in this case, we have a breach of contract case.
Okay.
It's between a homeowner and a real estate company. This homeowner, he agreed to list his house with the real estate company, okay? The contract, which referring to line 56 of the contract, provided that the real estate company would receive 6% sales of the sale price of the appellant's home. Now, looking at a careful reading of that contract, line 56, it talks about when this is to be paid. And it says, to be paid by appellant in readily available funds on the date of the closing. And then you have several listings here that evidence the closing, because it says, as evidenced by delivery of a warranty deed and payment of the purchase price, which includes payment of the purchase price in full, execution of a 1031 exchange, which I looked that up, and that's when you sell your property and you take that money and you invest it in another property, and it's a tax deferral. Execution of a deed of trust, execution of a promissory note. Where we run into an issue with this case is in the appellee's statement of undisputed facts. There is a sentence in there that says that the real estate company is entitled to this 6% commission upon the sale or the transfer of the property. So their argument today is going to be that Mr. Fuzzell transferred this property to himself and then to himself and to his new wife. They're going to say a transfer occurred, so my real estate company client, Town & Country, they're automatically entitled to 6%. Well, that is not what the contract says. So even if my argument even if my argument fails, that I had to respond to their admission, their request for admissions are deemed admitted. Even if that argument fails, I should come out successful on this, because here we are talking about the courts looks at a motion for summary judgment under de novo. If we look at de novo, we look at the proof that they had in the trial court. In the trial court, the appealee attached the contract to their motion for undisputed facts. They even cited to it, okay? But what they would have us believe is that when a transfer occurred, the real estate company is entitled to their money, which that statement, that claim is false. What it says is, at the closing of a sale is when they get their money. It never states that they get their money just because the transfer occurred. So in other words, if I list my house for sale, I decided I don't want to sell my house, I transfer my house to my son or to myself and my son, does that mean the real estate company is entitled to money? No, it doesn't. And under that same argument, I would argue, if you look at the language, it's under line 71 and 86, it provides that in the event a buyer is found for said property for an agreeable price, seller agrees to convey the property to the buyer, and the appellant is obligated to compensate appealee in the event appellant fails to close. Here, they have a problem. Their argument is flawed, because here, appellant never agreed to sell his house for the amount of $290,000. Okay, that's what the offer the real estate company brought. Here, it's undisputed that the appellant agreed to sell his house for $299,000. There was never an offer that was agreeable, or there was a contract on. So there was no breach of contract here.
Did the trial judge consider the failure to respond to the undisputed facts in this case? Did the trial court actually get to that issue as to the breach?
Your Honor, Your Honors, the trial court at the initial motion for summary judgment, which I was under the impression, and what I'm arguing today is I could show up. I could show up with Mr. Fuzzell. I didn't have to respond to their request for admissions. I could show up and I could argue what I just argued, but if that didn't happen, because as soon as the judge said, Mr. Hancock, did you respond to their request for admissions? And I said, no, sir. He said, that's enough. And that was pretty much the end of the first hearing. I filed a motion for the judge to reconsider. In that motion for the judge to reconsider, you'll see it's part of the record. In that motion, I state that even if their facts are deemed admitted, a real estate company is not entitled to 6% commission of $290,000 when the homeowner only agreed to sell the home for $299,000. That's unheard of. That is a frivolous argument, and if a client would have brought that into my office, I would have said, you didn't have a contract, I represent you. It's frivolous. So I did get to somewhat argue it at my motion to reconsider, Your Honors, but that answers your question.
But you didn't respond to the request for admissions at all?
They sent them on September. We partially responded, November, January, it was like months later. We did respond partially. There was an issue as to whether we were missing a page.
So not within the time allowed?
That's correct, Your Honor. So we have a lot of case law on this, and we have statutes on it. So I turned in my brief to Ware versus Meharry Medical College, 1995 case that provided that the circuit court hearing an appeal from general session court can exceed to $25,000. This case is probably where we all would pick up and say, okay, they say that Tennessee Rules of Civil Procedure Rule 1 applies in circuit court. Okay. But what this case stands for is that the circuit court can exceed the amount of $25,000 up to $75,000 in circuit court. That's what that case stands for. But looking back at the lineage of where we got to general sessions courts, we say today's general session courts trace their lineage back to the Justice of Peace courts, Weaver versus Cromer. They first appeared in Tennessee over 50 years ago when the General Assembly responded to the growing popular dissatisfaction with the Justice of the Peace courts, began creating general sessions courts by private act. So the general sessions courts were created by private act. In 1959, the General Assembly finally replaced virtually all the remaining Justice of Peace courts with a statewide system of general sessions courts. The general sessions courts share many of the attributes of Justice of the Peace courts. Like their predecessors, they are courts that touch elbows with ordinary people and provide justice in small, everyday affairs of life. That's Robert S. Keebler. They are not courts of record. That's State versus McClintock. Christopher V. Spooner, 640 Southwest 2nd, 833, 835, Tennessee Court of Appeals, 1982. And thus they provide many of the same informal procedures used in Justice of the Peace courts. Since the informality particularly suited the types of cases heard in Justice of the Peace courts, the General Assembly sought to preserve the same informality in the General Sessions courts. Litigants in General Sessions.
I'm really trying to understand why you're focusing on the procedure in General Sessions. This is an appeal from a judgment of circuit court. Why do we need to know any of that?
I am because of the statute, Your Honor. The statute that I referred to earlier that's been reformed, but every time that statute states the same thing. It says, it's the statute cited in my...
You still haven't told me why it's even relevant to what we're deciding today.
Well, it's relevant because of this statute that says that no case that derived from general sessions should be dismissed on an informality. So we think about what do we know about the case law about general circuit court cases that are heard in circuit court that derive from general sessions. Pleadings are not required.
You call summary judgment. What are you referring to the summary judgment motion as being?
I'm not arguing for the fact that you can't be granted a summary judgment in a circuit court in a case that derived from general sessions. I'm arguing that you can't be granted summary judgment in a circuit court case that derived from general sessions because someone did not do something written. Okay? I should be able to come into a circuit court case that derived from general sessions and argue my motion for summary judgment orally. What is it? Ori tennis. That has been that is the law, and that is what's been. Well, that is the proposition that I'm arguing for is because the informalities of the Justice of the Peace courts carried over to general sessions courts. Then our legislature, and I don't know why I can't find it, but it's in my brief, the statute. the purpose of this statute is to say that cases in general sessions should not be dismissed on informality, but should be heard on the merits. And then in my brief, you'll see, I think it's Vincent that says that cases in general sessions that may engage in discovery. There's no shall. So what I'm arguing is for the proposition that I don't have to do written discovery in circuit court in a case that comes from general sessions, and I don't have to respond written to anything, because if I was a defendant in circuit court case that come from general sessions, I filed a 12B motion, the plaintiff would not be required to respond. They wouldn't be required to respond because written pleadings would not be needed. So I'm saying written pleadings are not needed in motion for summary judgment. Thank you, Your Honor.
Thank you very much. Your point is taken. For the appellee,
May it please the court, my name is Craig Sanders. I represent the appellee
Yes, sir.
731 Real Estate Group, which does business as Town and Country Realtors. What the real issue before this court is does a circuit court judge have the authority under Rule 56 of our Rules of Civil Procedure to grant summary judgment when the non-moving party has never filed a response to the motion, has never filed a response to the statement of undisputed material fact?
Well, let me ask you, if you have a motion for summary judgment and the other side doesn't respond to it, does that relieve you of your obligation to show that you are entitled to a judgment simply because the other side doesn't respond? Because that seems to be what you're arguing. Simply because they didn't respond, you're entitled to a judgment.
My position, Your Honor, would be we are entitled to a judgment in this case because the statement of undisputed material facts and the request for admission, when they're deemed admitted, which they were and they should have been.
What admissions do you look to establish that you're entitled to a commission in connection with this property?
There's two important provisions of the statement of undisputed material facts, the most important being paragraph 3.
Paragraph 3?
Yes, Your Honor. Paragraph 3 says, pursuant to the contract that was entered into by the parties, Mr. Fuzzell and Town and Country Realtors, based on that contract, a 6% commission is owed upon the sale or transfer of the home. That's admitted under, it was not disputed, it was not.
So there was no sale here, right?
There doesn't have to
You
be.
never procured a buyer for the amount of the listing.
That's correct.
Okay.
And what Mr. Fuzzell wants the court, now, first of all, he's never made this argument. My position is it's been waived. Nonetheless, what Mr. Fuzzell wants this court to say is there has to be a sale of the property for there to be a breach. No, there's a number of different ways the contract can be breached and was breached. But this court doesn't even have to go through the details of the contract. We can, and I'll point out to the court while it was breached. But once paragraph...
Tell me how it was breached.
Sure.
I'd like to know.
There's two different provisions, the most important one being the 90-day carryover provision of the contract. And
Well, that only applies if you procured a buyer for the amount of the listing or reduced listing, and then later they sell to that party after the contract has expired. Those are not our facts, are they?
it's not in the facts that the home was sold to someone else.
Right.
The undisputed facts are that the home was transferred, the title was transferred. And that's important for the carryover provision.
Did he retain an interest in the property after this quitclaim deed?
Mr. Fuzzell did.
Right.
He retained part of it. And one reason that's important, Your Honor, I'd point you to paragraph 13 of the contract. And that provision says as follows: seller warrants that he is vested with good marketable title to the property with, quote, full authority to execute the agreement and to sell the property. Once he transferred that property to himself and someone else, he no longer has full authority to, and so that is a breach of the contract, right, because of the transfer.
Is the date of the transfer relevant, counsel?
The date of the transfer is relevant as long as it's within the carryover clause, and it is.
Oh, so you think the carryover clause would apply even though you didn't find a buyer for the listing amount?
Correct, and the reason I was...
What language do you rely on for that?
The carryover provision, Your Honor, in paragraph 3, it's on the top of page 5 of the appellate record, says, should the seller contract to sell or exchange or lease the property within 90 days after the listing to any buyer who has been introduced to the property directly or indirectly during the term hereof.
And so, did you introduce either directly or indirectly the person that he made the transfer to?
There's nothing in the record one way or the other on that, Your Honor.
Well, actually, if you look at your listing agreement, when did it expire?
The listing agreement expired in middle of April, subject to the carryover
April
provision.
14th.
Correct.
And then the transfer by quitclaim deed to himself and to his new wife,
Was on the 17th.
would that be after the listing agreement had expired?
It would be subject to the carryover clause. It would
Yeah,
be,
but the carryover clause only applied if you introduced him either directly or indirectly to the party that he transferred to later. And that's not the case here, is it? And that's not mentioned in your request for admissions.
it's not mentioned in the request for admission who introduced Ms. Shoemaker to.
Well, you would have to establish that if you want to apply the carryover provision, wouldn't you?
Our positions, we would not, because is there a sale, exchange, or lease of the property, someone directly or indirectly introduced to the property? It doesn't say that it has to be who introduced the person to the property.
Oh, I think it's implicit in the listing agreement that it refers to the agent. That's implicit. You don't have to spell it out. It's implicit in the agreement.
I would also point out paragraph 6, Your Honor, which is the general provision on compensation. It says 6% commission will be paid, and it has a number of things, including but not limited to, and it says payment of full purchase price, execution of an exchange, execution of a deed of trust. It's basically saying any transfer of this property, there's a 6% commission to be paid. I think that's another area where the contract,
And that's what you're relying on.
we're relying on those three provisions, paragraph 3, 6, and 13.
What did the trial judge rely on when in his order? Did he rely on the failure to respond, or did he rely on the factual situation as a result of the agreement?
The trial judge relied primarily upon that there was no response to the motion at all, as is mandated by Rule 56, and is mandated, of course, by the court's local rule as
The
well.
question then, are you entitled to a default judgment just because there was a failure to respond?
Our position, Your Honor, we were entitled to summary judgment once there was no response to the statements of undisputed material fact, which included a statement that says the interpretation of this contract is that if there's a sale or transfer of the property, then their commission has to be paid. The plaintiff has never raised in the trial court these arguments. He's never raised the arguments of, well, he interprets the contract differently. That's something, if he wanted to make the argument, he should have made in the trial court. This court has said many times, as well as our Supreme Court, that issues not raised in the trial court cannot be raised for the first time on appeal, and that's really what the plaintiff is trying to do.
Well, how's this any different from filing a lawsuit against somebody? They don't respond to it, don't answer, you get a default judgment. After you get your default judgment, can you just walk in the court and ask for any amount that you want? Or do you have to show that you're entitled to it?
You would have to put on proof as to, well, I guess it depends on the type of case, but
Okay, well, I'm trying to figure out how, from your request for admissions, even though he didn't respond, how does it show that you're entitled to a judgment for sales commission? Because you never secured a buyer. And his transfer was after the listing agreement had expired. And it was not to a party that was introduced by the agent. How do you get a commission under those facts?
as I said, Your Honor, we rely on those three provisions of the contract, that if there's a sale, exchange, lease, et cetera, and also his warranting on paragraph 13 that he will have full authority to transfer, and that would include full authority to transfer within 90 days. Let's say this happened.
Did the trial judge present that in his order?
He stated in his order that based upon the transfer, that's why he was granting the motion. He didn't lay out the express reasons, but it's the transfer, and the transfer is what's important. Let me give this hypothetical to the court. Let's say after the initial expiration date, but within the 90 days, a buyer who the real estate agent undisputedly brought to the table, he can't transfer the property anymore. So once he transfers the property to himself and Ms. Shoemaker, he has breached the lease.
But notice you said a buyer that the agent brought to the seller. Those are not our facts, right?
We don't know.
We don't know. I mean, you don't have any request or admission that indicates that those were the facts. So even, we don't have anything that you can deem admitted that makes out those facts. Do we?
I think what we do have, Your Honor, is the provision in the paragraph which says introduced directly or indirectly during the term hereof. It does not say what indirectly means. It does not say the broker brought. The way the contract reads, and this is the contract that he entered into, is that if there's a sale, exchange, a lease, et cetera, within this carryover time period, then there's a 6% commission.
I've heard you say a couple of times the phrase "any transfer of the property," and I've tried to keep track of which provisions of the contract you're speaking about, and you've mentioned 3, 6, and 13. Is there anywhere in the contract that it uses that phrase, "any transfer of the property"?
No, I was using that phrase, Your Honor, because that's what's in the statement of undisputed material facts and the request for admission.
Okay, is there anything in the record that sort of defines these particular terms as any transfer of the property? If that makes sense.
I understand, Your Honor. There's nothing that defines the terms in the contract. It's a contractual, it's an interpretation issue, and our position is any arguments about that have been waived because they weren't made. There's one pleading that was filed by Mr. Fuzzell in the trial court in regards to any of this, and that was his motion to reconsider. And that it's a one-page motion, and all it talks about is this statute that we heard counsel talking about. And that's the position he took in the trial court. And that's what this court should consider is that statute and the arguments about that statute right or wrong. And I would submit that it's incorrect. That statute, as interpreted by the court in the case where Meharry Medical College, which was cited by counsel, expressly says that applies to informalities in the Sessions Court. It doesn't apply to informalities in the Circuit Court, and certainly responding to a motion for summary judgment would not be an informality regardless.
Was there, and I read the briefs, but do I remember that there was a transcript of that hearing?
There was no transcript. Mr. Fuzzell filed a motion with the court asking the court to submit a transcript, but the court did not have one to submit.
Okay, so there was no court reporter for that hearing.
That's correct.
All we have to know about which arguments were made were the motions and the court's order.
That's correct.
All right, but you're representing that these arguments about what's encompassed in this contract and a transfer of sale were not argued before.
Yeah, the only thing that's in the court file is the motion to reconsider, which is basically a one paragraph that says, I'm immune from summary judgment. I'm immune from discovery because of this statute, irrespective of our very first rule of civil procedure, which expressly says these rules apply to all cases in circuit court. And if that wasn't enough, it goes on to state it includes cases appealed from the General Sessions Court to the circuit court. So Rule 56 applies, there's no doubt. Rule 56 mandates a response to the motion for summary judgment within 5 days of the hearing. Here we had approximately 4 months, never got a response. Never got a response to the statement of untreated material facts, which interpret the contract. And so I don't think this court should go back and reinterpret the contract.
He indicated that there was a partial response to some of the requests to deem admissions for admitted. And I think he conceded that those were done well after 30 days. What am I going to find in the record when I go looking for that?
You're not going to find any response whatsoever in the record. You will find a statement in the court's order referencing a response. But one thing I'd like to point out is, one, as Your Honor noted, these are way after. They're untimely, and they shouldn't have been considered for that reason alone. But two, all the order says is partial responses were emailed. It didn't say they were sufficiently served under Rule 502 or any other rule. So there's nothing in the record showing that any of these were ever appropriately responded to or served, and the only reference there is there's an email to partial responses, and there was never a response to paragraph 3, which I think, as I stated earlier, is probably the most important of the paragraphs in the Statement of Undisputed Material Facts. In closing, I'd like to point out one case by the court. It's a recent case, Builder's First Source versus A6 Dynamics. It's a February 2025 case by this court. It's very similar. Appeal from General Sessions Court, no response to Statement of Undisputed Material Facts, no response to requesting admission admitted, summary judgments affirmed, and attorney's fees are awarded.
What was the name of that?
Again, the name is Builder's First Source versus Axis Dynamics, and it's 2025 Westlaw 574388.
Has this case been cited in your brief?
No, that's a newer case that was not cited.
If you desire that we look at that case, you need to send the citation of that case or a copy of that case to the clerk to be delivered to us, okay?
Yes, Your Honor.
Let me ask you, counsel, since this is a contract case and we can look at the contract and determine the terms, and you've got your motion for summary judgment, you've got your admissions, let's assume they're all admitted, which is fine, they're all admitted. I'm still struggling with how from those admissions, you establish that he breached the contract, which entitles you to a fee, or your client to a fee.
I would respond as follows, Your Honor. He has, by not responding to those statements and those requests for admission, he has essentially admitted that, or acknowledged or waived an argument as to his interpretation of the contract to the interpretation that we take, which is that it's based upon a sale or transfer.
Does that prevent us from looking at the contract and reviewing it and making a determination about the terms?
I think that argument's been waived by the plaintiff. I don't think this court should do that.
The fact that he waived the argument, he failed to respond, does that automatically prove your case?
Once he didn't respond to those paragraphs, it does, because it establishes two important facts. One, that the contract means, those paragraphs mean that if there's a sale or transfer, the 6% commission's owed, and another paragraph acknowledges that there was a transfer. So if there's a transfer, you get 6%, and there was a transfer, that's been waived.
And you don't dispute, do you, that this transfer was after the listing agreement had expired, nor do you dispute, do you, that the person that he transferred to was not someone that was introduced to him by the agent?
What I would say in response to that, Your Honor, is I would agree that the transfer took place after the initial expiration date, but within the 90 days. So I would not acknowledge or not concede that the contract's not in effect. And then in response to introducing the person, I don't know. The record doesn't state one way or the other, but I would submit that it's not mandated under the contract.
And you don't read the 90-day extension to mean when the agent has introduced someone to the owner, made an offer, and then the owner fails to close within the time of the listing agreement, that listing agreement gets extended for 90 days. That's not how you interpret that provision.
Our interpretation is that any transfer after, within that, any contract for sale, transfer, lease, within that 90 days would cause the 6% provision to apply.
And we base the 6% on what? What amount?
It's based upon the sales price, which in this case, $299 was the sales price, or the price but it's actually based on the 290, which was a more fair way to do it for Mr. Fuzzell, to base it on the last official offer.
And that 290 was someone that was introduced to the owner, right?
That's correct.
And that offer was an offer that was rejected.
It was never considered, and the court found that because of the divorce proceedings, and we can get into that, whether that's also another reason for a breach. If you don't consider a legitimate and valid offer and don't act in good faith, is that yet another reason that there was a breach?
Okay. Thank you.
Thank you.
Your rebuttal, sir?
Your Honors, if we look at that builder's case that he referred to, if we look at the builder's case, there's a difference between it. No attorney ever showed up to argue at the summary judgment. That's the difference. I'm not arguing for the principle that we can't have summary judgment in a circuit court case that derived from general sessions. I'm arguing that we can't have summary judgment based off technicality that includes written pleadings. If we look at that Vinson case, it does say that you may take the opportunity to do written pleadings if time permitted. The statute has been changed over the years and over the years. It started out way back when, 1844, they were quoting to 19425. In 1984, they were quoting to 191118. And then the one I quoted to.
If you would address Mr. Sanders' argument about just the transfer itself within the 90 days gives his client a right to the commission. What do you say about that?
I know, Your Honors, we're listening closely to what he said. That is so flawed. What he is saying is, because Mr. Fuzzell transferred the property to himself and to his new wife, he is no longer the sole owner. And if the Town and Country were to bring him an offer of the $299, which he agreed to, he can now no longer accept it because he's not the sole owner. That is what their argument is. Their argument's based off a hypothetical that...
Let me ask you, Mr. Hancock, let's suppose he didn't transfer on the 17th of September and he made the transfer, the 17th of April. If he made the transfer on the 1st of April, would that fact pattern be different, authorizing a commission?
It would not, Your Honor.
Why would it not be different?
Here's the deal. I have bought and sold. I've built 7 houses. I know that contract means if I bring you a buyer for $300,000, you told me you'd sell it for $300,000.
No, but the contract says that if you sell the property within the listing period and you no longer have a right to accept an offer, they're entitled to a commission. This transfer would have been if the transfer was made on the 1st of April, that would be during the time of the listing agreement.
I don't know
Would this case be different
that's how
if
it's
those were the
stated.
facts?
I don't know that it's stated like that. The way I've always understood these contracts with real estate companies.
Not these contracts. We're just talking about this one contract. That's all we're talking about.
Okay, so they're saying that if he was to sell the property, then they could no longer bring a buyer in for what he had originally agreed to, then he would owe them a commission.
Yes.
Okay. Well, I would go back on my argument and say that he still has an interest in the property. They did not bring him a buyer, and all this is hypothetical, and it's moot because they didn't bring him a buyer. If they would have brought him a buyer, then we would be having a totally different discussion, Your Honors.
Thank you, sir. Madam Clerk, will you call the next case? Well, let the lawyers